Really pleased to be here today to talk to you about my new book with Edward Elgar, The Future of the Employment Contract. Now, the employment contract has been the focus of my research and my writings for many years, and I've been publishing on it since the early 1990s. But this project's a bit different for me. It's not a comprehensive work on the employment contract. Of course, there's many other excellent works that serve that purpose. But what I try to do in a project I've been thinking about for quite a while and which very much excited me, I've been trying to write something that tries to predict, assess just how the employment contract might evolve in the years ahead. My starting point, though, is just how much the employment contract has changed over the last 40 years. And the reason the law in this area has changed is because the judges have changed their mind about certain absolutely fundamental points. The judges now are of the view that the employment contract possesses certain very key attributes, and that recognition of those key attributes influences how they decide cases. So, for example, judges now accept that the relationship is characterized by a very significant inequality of bargaining power between employer and employee. They acknowledge that's not always the case, but it's almost inevitable. Now, at one point, the common law would not have taken that view at all, and the view that the employment contract was one showing disparity of power was a view confined to academics such as Kant Freud in the utterly seminal work, Labour and the Law. But the judges have changed their mind, and that's been a very interesting process. They've also taken the view that the employment contract possesses some other fundamental attributes. It's a relationship which is one that the employee gains not just financial benefits, but a variety of other benefits from working and actually being part of the community that work involves. And again, that informs how they go about decision making in employment cases. It's also the case it's become apparent that judicial thinking is underpinned by a number of values which the common law judgments display. And I've been influenced here by Don Oliver's excellent work. And I think that Professor Oliver's work can also be applied in the employment context, and that values such as respect, autonomy, and so on also played a part in judicial thinking. But how might the law develop next? My starting point is to say, well, will this recognition of key attributes, will this acknowledgement of underlying values, will it continue to have an influence on evolution? And I think the answer to that is almost certainly yes. But I've also been interested to explore whether wider developments in the law of obligations that we've seen in recent years, whether these wider developments will also have an impact on the development of the contract. And I've focused on three different developments in the wider law of the law of obligations. One's the increasing influence of enterprise liability in the law of tort. The second is relational contract theory. And the last is the rise of concepts of good faith and fair dealing in the law of contract more widely in a variety of jurisdictions. If we take enterprise liability first, this concept had a huge influence in the law of tort, particularly where the law of vicarious liability is concerned, and often against a backdrop of very unfortunate cases involving abuse of children and other people. The courts have taken the view that the enterprise and the employer are responsible to a range of people for a wider range of workers and others that previously they wouldn't have been responsible for. The question, I think, then is whether that reasoning will be extended to the employment contract to make the employer increasingly responsible to those that work for him, and perhaps a wider range of workers will be covered by common law protection as a result. It's also the case that enterprise liability compels you to focus on questions of allocation of risk. And traditionally, the employment contract has been somewhat harsh to the employee where certain risks are concerned. So, for example, if you incur psychiatric harm in the course of the employment. It's quite difficult to recover apart from quite a limited number of situations. And again, even more so, if you suffer purely financial loss in the course of the employment contract, it's harder still. There's some obvious exceptions now, like the position in relation to references, as a result of the major case of the House of Lords in spring against Guardian Assurance, but that remains an exception. I've then moved on to look at the impact of relational contract theory. I've been very influenced for a number of years by the work of the late Ian McNeill and his very famous and celebrated book, The New Social Contract. And the judges now accept and will say that the employment contract is indeed a relational one. But what does that actually mean? And particularly, what does it mean for the law's development? In the course of writing the book, it's been interesting how my own views have evolved and changed, and I've become something of a relational contract skeptic in the course of going through this. So I'm not convinced that relational contract theory is going to have a big impact on how the law changes moving forward. And lastly, as I've mentioned, I want to look at the impact of notions of fair dealing and good faith, which have become much more prevalent in a variety of common law systems around the world. Will those wider developments in the law of contract, will those developments lead to the possibility of employees challenging the fairness of the bargain in a way that they haven't been allowed to do so in the past? So there's some quite interesting, some quite big questions to be posed, and I've tried to do that in the book. Mention of fair dealing takes me neatly into the approach of the case law of the Canadian Supreme Court. There's been some fascinating jurisprudence which has emerged from Canada. The Canadian courts, for example, were very early adopters of the view of Can Freud and other academic writers that the employment contract was marked by a disparity of bargaining power. And in recent years, again, some of the judgments of the Supreme Court in the employment context have been absolutely fascinating. And I've discussed them and posed the question of their potential relevance for us back in the UK. Another issue which has traditionally been underplayed, though it's getting more attention nowadays, is the relationship between statute and the common law contract. Statute can be both a source of stimulus for the contract, but it can also be a reason for constraining common law development. One of the later chapters in the book explores how that might play out in the future, and also acknowledging there's been some tremendous writing on that in recent years, and very much including Alan Boggs' article in Current Legal Problems. Now, only a fool would try and predict the future, but it's been great fun doing so. And even in the time that that the work's been in the hands of Edward Elgar, going through their highly efficient production process, there's been some major decisions. And if you take, for example, the Uber decision, where it was rightly portrayed as a big victory for workers and the employment protection rights that they sought, at the same time, surprisingly, the courts were, at the Supreme Court level, somewhat more cautious than they have been for a long time about this notion of inequality of bargaining power. And what I take from that is that things are never settled, and evolution doesn't always go as smoothly or just in the way that you might expect or anticipate. Well, I hope you've enjoyed this summary of the work, and if you do find time to read it, I'd be very interested to hear your views. I've got very broad shoulders, so don't hesitate in coming forward with critical comment, and I can be reached by email, and I'd be very happy to hear your views and indeed very happy to respond to them. And that's all for now.